morning and good afternoon to in-house counsel from all across America. Welcome to In-House Connect. My name is Shai Mahani. I am the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunch time with us. And special thanks to our wonderful sponsor, Lord, and our fantastic presenters today, Richard Reibstein and Chris Fontanelli, for putting together a fantastic presentation on updating and enforcing non-competes and trade secret agreements for in-house counsel. For those of you who are here for the first time, let me give you a quick bit of background on In-House Connect. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect would organize free CLE classes, which were hosted by different law firms, including Lord, and which were then followed by cocktail networking receptions. And every 6 months, we would organize fun and festive networking mixers. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then of course COVID hit. We couldn't meet in person, so we met online, and it's been a fantastic transition. We've been able to attract a much larger audience of in-house counsel, truly from coast to coast, and we've been able to feature high caliber speakers like the two we have today. So this is actually our 32nd event of the year. So I'm wondering, are you here for the first time, or have you been with us before? We're right under 30% new attendees to our event. So that means, about 70% are returning. So welcome to the 30% and welcome back to the 70%. Let's get to today's program, which is updating and enforcing non-competes and trade secret agreements. Our presenters today are Christopher Fontanelli and Richard Reibstein. Chris Fontanelli is a litigator whose practice focuses on two distinct but related areas of law: complex commercial litigation and labor and employment. In the area of complex commercial litigation, Chris represents clients in class and collective actions, commercial contractual disputes, and product liability and mass tort actions. In the area of labor and employment law, Chris counsels clients concerning a wide variety of matters, including disputes relating to discrimination, sexual harassment, employment agreements, wage and hour violations, employee misclassification, misappropriation of trade secrets, and enforcement of restrictive covenants. Chris has extensive experience in New York and New Jersey state courts and federal courts throughout the country and understands the nuances of litigating matters in the public eye. Our next panelist is Richard Reibstein. Richard is an experienced labor and employment law practitioner who has advised companies and litigated cases across the country in the areas of unfair competition, trade secrets, and non-competition agreements. Richard crafts corporate protection plans and negotiates and drafts state-of-the-art non-compete agreements, confidentiality pledges, and other types of restrictive covenants. He counsels clients on securing compliance with such agreements by departing employees and their new employers, and conversely, how to lift out key employees of competitors who have signed these type of agreements. We are so fortunate to have such a knowledgeable panel on with us today to teach us best practices on how to update and enforce non-compete and trade secret agreements. And with that, I'll turn things over to Rich to get us started.
Thanks, Shai. Let's start out with a question instead of an introduction to our talk today. So on the slide that says question for attendees, if you can, select the particular last time that your company updated your employee agreements covering confidential information, trade secrets, and any restrictive covenants. Okay, we'll get the results of those shortly, but let me just say that these types of agreements are called all different things. Sometimes they're called confidentiality agreements, sometimes restrictive covenant agreements, sometimes non-compete and non-solicitation agreements, or a combination of the above, or sometimes just part of an employment agreement. I recommend that you consider calling them loyalty agreements for at least 4 reasons. First, none of the other titles reflect all of the contents typically. Second, it's best not to include in an employment agreement these types of provisions, although it's okay, but it's better to have as a separate agreement, even if referenced in an offer letter or in an employment agreement. Third, it sounds more positive, a loyalty agreement, than a non-compete or non-restrictive or non-solicitation agreement, or something called a restrictive covenants agreement. And fourth, I like to include a faithful and diligent service provision in loyalty agreements. Should you include non-competes along with non-solicitations and confidential information protection in the same agreement? So non-competes is definitely different. Non-solicitation and confidential information, provisions protect the company, whereas non-competes not only protect the company, but also in a meaningful way can restrict employees. Non-competes are not for all employees. This is a decision point. It should be thought through carefully. Non-competes are also tough to enforce, sometimes extremely difficult in many states. If you want a non-compete, do you make the enforcement easier by adding a garden leave provision where the employee is paid the full amount of his comp while on ice? If you ice an employee, do you want to, use a de-icing clause where you no longer need to pay the employee any of the, garden leave pay? That brings us, to the next question we have for all of you. If you can advance the slide, Michaela. If you have a non-compete clause preventing departing employees from working for a competitor, how long is the non-compete clause for? And for all those of you who can't see the poll, but 12 months is the overriding number by far. 67% of all of these non-competes are for 12 months. Chris, take it from here.
Sure. And Shai, this was a good recommendation with the polls because it's great to see this in real time and receive that information. I expected 12 months to be the majority of the answers. So jumping off of what Rich was talking about, non-competes are enforceable in some states. They're not enforceable in other states. There's certain rules that companies must honor. And although I could frankly spend the entire hour or multiple hours talking about various different states, I don't think that'll be best use of all of your time. We're always happy to discuss certain state-specific questions, after this. But I did want to discuss some states to give you an idea of the landscape and why it's so important, in our view, that companies are regularly looking at these loyalty agreements. So let's talk about, for example, California. So for California, other than very narrow exceptions regarding, let's say, the sale or dissolution of a company, California has a strong policy that disfavors non-competition agreements. Although at times there's certain cases that have been published relating to the disclosure of trade secrets and those being protected, generally speaking, what we see in California is that if it's a non-compete agreement, it's unenforceable. Now, you take that all the way to the other side of the country, New York, New Jersey. So with New York, non-competes are generally enforceable as long as they are reasonable in time and area, necessary to protect the legitimate business interests of the employer. They're not harmful to the general public and not unreasonably burdensome to the employees. And what you'll see when we talk about some of these states is the reasonableness requirement tends to run through many of those state common laws. And we're also starting to see some of the states are codifying these and placing their own spin on them, which is another reason why it's so important to be monitoring these, whether it be a bill that was just introduced or a law that was passed. So for example, New Jersey, very similar to New York. And right now we're litigating several cases relating to New Jersey restrictive covenants. So New Jersey, although very similar to New York, has a bill that was passed, a bill that was proposed over the past year. And what it intends to do is provide more limitations on restrictive covenants. So some of those include both pre and employment and post-employment notice provisions. There's a 12-month limitation on the duration of post-employment restrictions, whereas right now the case law suggests it's generally okay if it's up to 2 years. They designate certain classes of employees who are not subject to restrictive covenants. And there's also, I think Rich alluded to this before, the garden leave. Similar to that, there's post-employment payment obligations. So that's one that we're closely monitoring, because that, not that it would turn the law on its head in New Jersey, but certainly employers would have to take those into consideration with respect to notice requirements and whether or not they would be included in their loyalty agreements. Another couple of examples. So a state in Pennsylvania, let's say Pennsylvania. So in Pennsylvania, they have similar reasonableness requirements, but continued employment is not considered sufficient consideration for including a restrictive covenant. So what ultimately will happen there is, although in certain states you can introduce restrictive covenants while the employee is employed, and that continued employment is sufficient consideration, in Pennsylvania and some other states, it's not. So what we try to do is we look for opportunities, whether it be bonus payments or it be a promotion, to work in some type of consideration, right? Because outside of that, you may think you have a non-compete that's enforceable, but when you finally look to actually enforce the non-compete, realize that there was not proper consideration and therefore it would get thrown out. A couple more states, and then I'd like to kind of turn the page, but Illinois is a really good example because Illinois has all new restrictions that were effective January 1, 2022. Some of those have new salary thresholds where I believe it's $75,000 or less. You cannot hold them to a restrictive covenant. Reasonableness in time, scope, those were codified. And a few other things that we've seen where there's notice requirements. And I think as you will recognize throughout today's presentation, notice requirements are going to be critically important because some of these states that are codifying the common law or have imposed certain restrictions, if you don't provide those notices in either the employment agreement itself or thereafter, if you seek to enforce those non-competes at a later time, the court may not even consider it. It may be unenforceable. So there's a few other states, Florida, Massachusetts, and Georgia. Those are ones that we're keeping an eye on as well, because some of them validate non-competes, but again, the tests are generally reasonableness. And we could of course go offline and talk about those states. But one of the other things I wanted to raise that I think is critically important is understanding which of the states have red pencil reformation or blue pencil doctrines. So red pencil being, one provision in the non-compete, only one provision or a line. If that is found to be unenforceable or overbroad, the court will likely just throw out the entire covenant as unenforceable. And then you're left with nothing. In many of the states, we see reformation, which is they can tweak the agreement. And by tweaking the agreement, the court can take an agreement that may be unenforceable or certain provisions are unenforceable and make it enforceable. So for example, Pennsylvania, Florida, Illinois, New York, New Jersey, those are those types of states that allow for that. And then you have blue pencil states, which are more, the court can strike certain provisions that would otherwise render the clause unenforceable, and that then would create the enforceability of the clause. And that's states such as Connecticut and Georgia. So essentially the takeaway here, and what I hope the takeaway is that a one-size-fits-all approach on restrictive covenants that are provided to all types of employees is very much likely subject to attack. And employers often need to take a look at that and craft their restrictive covenants, whether it be for different roles, different states, different areas of the country, and some roles may not even require restrictive covenants. So Rich, I'll kick it back to you because like I said, I can talk for a whole hour and a half on the various different states and their restrictions. But of course, we're happy to talk offline about, very state specific questions.
Thanks, Chris. I think Chris's last point is extremely well taken. And that is, take a look at those poll results again. There are 11% at 6 months, 67% at 12 months, and 24 months has 10%. So I've got a rule of thumb in states where non-competes are enforceable, and that is every additional 6 months of a non-compete divides by half the likelihood of enforcement. And what I mean by that is if you have a 6-month non-compete, it's probably twice as likely to be enforced as a 12-month non-compete. If you add another 6 months to that and have 18 months, well, you start to divide the likelihood of enforcement, by, half again and again. So what we like to do is to try to encourage companies to keep the duration as short as possible to actually serve your company interest to increase the likelihood of enforcement. I personally am a big fan of a 9-month non-compete. It's long enough to make other companies uninterested in extending an offer to the worker, and short enough to have a damn good chance of enforcement. We say the non-solicitations must be truly protective and not afford clever lawyers a workaround. Well, unfortunately, many customer non-solicitation provisions are, drafted with big loopholes. Words like no solicitation, not impairing customer relationships, or diverting work are loopholes that we have to work around because they can be dodged by the counsel for a departing employee. If a customer calls a former sales employee, has the employee solicited that customer? Has the employee done anything to impair or divert your business? It's not clear. So we always draft non-solicitations with language that prohibits doing business with our clients' customers and prohibits any action to aid or facilitate the new employer in doing business with such customers. So that brings us to the next question for all of you on the presentation here. Does your company's, if you can advance the slide, Michaela, does your company's customer non-solicitation agreement cover only a few selected clients, only clients of the company with whom the departing employee was involved, or all clients of the company?
So one thing that I wanted to, while we're looking at the poll results, one thing that you mentioned that I think reverts back to something I was referencing, right? With these different states having different laws, and some of which are now codifying them. One thing that I have noticed over the past year in reviewing many of these laws is that they are starting to place specific restrictions on the number of months or years. Frankly, it's usually months. It's few states that restrict by way of years. And it's important to note because for some companies that have employees that are across the country, you may have employees who are working in one state that the state restricts anything more than 6 months. You may have another one where in another state, it's more than 12 months. And what we've seen in some of the cases, unfortunately, is that we're presented with non-compete agreements that the client asks us to look at, and we unfortunately have to inform them that there's certain provisions that may not be enforceable because that specific state specifically prohibits the restrictions that they use for all of their employees throughout the country. So I wanted to make a note of that.
And that's an excellent point, Chris. Let's see, the poll for slide 7 is exactly what I would have expected. About a third have only clients of the company with whom the departing employee was involved, and about half have all clients of the company. So in New York and other states, non-solicits need to be drafted correctly. There has been in New York for the past 23 years a case called BDO Seidman. Chris, if you could just talk about that for a second or two. I want to go back to the poll, and if you can incorporate the results of that poll, that would be terrific.
Sure, very interesting poll, and I think, as you noted, not surprising, and there's a lot to work with there. So BDO Seidman, for those of you who are not familiar with the case or don't have offices in New York, so BDO Seidman, it's really the seminal New York case. It's a court of appeals case, which in New York is the highest state court. And it found that the plaintiff, which was an accounting firm, had a legitimate interest in preventing the defendant employees competitive use of client relationships, which the company enabled the employee to acquire through the employee's performance of accounting services for the clientele. Now, what's critically important, though, in New York and many states, many states, is the Court of Appeals in BDO Simon specifically held, though, it would be unreasonable, and I'll quote it would be unreasonable to extend the covenant to personal clients of the defendant who came to the firm solely to avail themselves of his services and only as a result of his own independent recruitment efforts, which BDO Simon, the plaintiff, neither subsidized nor otherwise financially supported as part of a program of client development. So frankly, right, what does that mean? Really what it means is, for many of the cases that we've seen that interpret BDO Simon, or the courts are interpreting BDO Simon, a strict prohibition on contacting any and all clients of the company tends to get struck, because you have employees who, let's say in the financial space, have their own personal clients they perhaps brought to the company, or that they engage with, solely for their own practice, and to try to prohibit any communications with or continued work with those clients would tend to be found as unreasonable, and that the company would not have a legitimate business interest in preventing that individual employee from competing with the business. So although in New York these types of restrictive covenants are generally enforceable, I think BDO Simon, holding that in order for them to be enforceable, they must be reasonable. They need to be necessary to protect the interests of the employer and not harmful to the public, and not unreasonably burdensome. I think when you look at the unreasonable burden and also protecting the business interests, it gets to the critical point, which is, if a court is looking at a non-compete and trying to determine whether or not it's overbroad or enforceable, it will look to see which specific customers, which specific clients that non-compete is prohibiting that employee continue to contact or work with. So Rich, happy to hear your thoughts or any takeaways, but I think one of the takeaways for me is that, in New York, a company is going to have a very hard time attempting to enforce a restrictive covenant that prohibits contact with quote unquote all customers or clients with whom the employee never worked or even knew of.
And just to clarify, the middle answer, only clients of the company with whom the employee was involved in business matters, is what BDO Simon permits, in addition to making sure that they are not prohibited from, taking with them their own personal customers that they brought into the business. So with the 51% of the folks who answered that all clients of the company, that is certainly enforceable in some states. In New York and other states, however, it would not be enforceable. And the reason is as follows. If an employee, this is the rationale of BDO Simon Court, if the employee had no exposure to that particular customer when they were working at the company, then the company has no interest in protecting that, because it didn't introduce that employee, to that particular customer. So what we like to do in any event, even for those states that allow all clients of the customers, is to try to follow the BDO Simon, contours, and only limit former employees from dealing with customers with whom they had a relationship with. As a practical matter, those are the ones that, if you go into court, are far more likely you're going to receive injunctive relief. If it's for all customers of the company, that makes it much more of a challenge for lawyers. Michaela, if you could advance to the next, I wanted to mention one thing though, Chris. You can put into a loyalty agreement a provision that deals with these personal clients. So for example, you can require an employee to promptly notify the company in writing as to any new customer that has joined the company solely as a result of a prior relationship with the company. Now, one trick I like to use is requiring a 1 to 2 week notice period in the event of resignation or termination by the company with those employees who have customer-facing roles, and stating that the employee is required to assist the company in transitioning his or her work to a new company employee. So instead of showing the departing employee a quick exit and giving them, pay in lieu of notice, we like to suggest that companies consider something according to the following. Have the departing employees access to, all of their computers removed or extremely limited, but directing the departing employee not to communicate with any customers unless there's a member of management on the call with such customers. And we suggest that calls be arranged with all customers, with the departing employee and the manager, and sometimes the new worker who will take over the customer relationship, to actually foster an effective transition. By doing so, it makes it very challenging for the departing employee to try to capture a relationship with a customer that they've now handed off to another employee of the company. So one final issue with regard to non-competes and non-solicitations. Do you have employees sign new loyalty agreements, or do you amend your existing agreements? Now that depends on the state or states involved, but there can be a huge difference in the outcome of any litigation or threatened litigation against a former employee unless you do it in the best way. And that again depends on the state and the circumstances. Again, the question is, do you have employees sign new employment agreements, new loyalty agreements, or do you amend your existing agreements? And if you have any questions about that, of course, we can answer that offline. Does your employee agreement or employee handbook provision have a return of company property that specifically covers the return of electronic information? Yes or no? Well, overwhelmingly, the answer is yes. It does specifically cover the return of electronic information. That's great, except it's very difficult, actually impossible, to return electronically stored information. You can't just return it. It has to be deleted or destroyed. But then do you want the departing employee to delete or destroy it? Quite frankly, it's not too hard just to shoot it to another, memory device or another Gmail address. So we suggest including language that if an employee has any of your property containing confidential information, they're required to give you a list on their departure of all property in the form of electronically stored information in his or her possession, give the list to the company's IT department, and cooperate with the IT department to permanently delete any and all electronically stored information and destroy access to all such information. And that includes on the employee's Gmail accounts or Yahoo accounts or other types of memory devices. So this brings us really to one of the most important parts of the presentation that Chris is going to address now, and that's the DTSA.
So the DTSA, what is it? I suspect many of you have heard of the DTSA, but some of you may have not. So the Defend Trade Secret Act, that was enacted in May of 2016. And what it allows is U.S. employers to protect against and remedy misappropriation of trade secret information in federal court, right? Why do I say federal court? Well, it was a federal law. And it's been interesting to see the development in the DTSA case law over the years. So what before we get into some specifics, I can give you a general sense of kind of what does the DTSA prohibit and what do you need to do as an employer to plead a claim under the DTSA, since we're starting to see more and more of them. So to state a claim under the DTSA for any type of misappropriation of trade secret information, plaintiffs need to allege, frankly, two primary things. One, that it possessed a trade secret, and two, that the defendant misappropriated that trade secret. Seems simple enough. And the DTSA, although it does define misappropriation to include acquisition of trade secret information by folks who have reason to believe that it was acquired by improper means, you can imagine that the case law is still ongoing and evolving as they interpret what does it mean to misappropriate trade secrets, or what is a trade secret to begin with. But for the sake of brevity, trade secrets under the DTSA have been interpreted as being quite relatively broad, and the statute itself broadly defines the types of trade secrets that are protected. So this was an important law because in certain states that may have trade secret acts, right, to state trade secret acts that were followed by or under the Uniform Trade Secret Act, most of the misappropriation cases of trade secrets and confidential information were sought by way of state court. And you had state court common law and state court Trade Secret Act disputes. So now what we've seen is the DTSA has found its way into many cases over the past few years. So I was taking a look ahead of the presentation at some of the statistics that are reported each year, and nearly 75% of trade secret cases were brought before federal courts in the past 2 years, and those cases tend to include a DTSA claim. So in my view, the statistics are clearly showing that there has been a rise in the DTSA litigation since its enactment, and it has continued to kind of steamroll ahead. And frankly, we can talk more about whether or not to include DTSA provisions in confidentiality agreements, what needs to be included, and the pros and cons of bringing a DTSA claim in federal court. But I wanted to provide just a general sense of what the DTSA is and what it prohibits, and why it's important for the sake of employers all over the country. And Rich, if you have anything else to add, please, feel free to do so.
No, you're on the most important part here of all. And just to clarify, the DTSA gives you access, which Chris will talk about, to something that state laws don't ordinarily give you access to, and that is federal court.
And it's critically important. I mean, availability of remedies and the notices that are required. Let's talk about the availability of remedies first. So under the DTSA, there's a broad net of available remedies available to employers. You can go into federal court requesting injunctive relief. You can request monetary damages. You can request punitive damages. Typically, what we've been seeing is that the exemplary damages that are available under the DTSA are essentially double damages. And then what we can talk a little bit further about is the attorney's fees provision under the DTSA. So with respect to the attorney's fees provision, which tends to light the kind of light the signal for some of our clients as to, hey, you can bring a DTSA claim, and then at the end of it, we can request attorney's fees. Yeah, sure, go ahead and do that. Well, one of the things that we've tend to look at is, did the client or did the company, did they satisfy their notice requirements in order to request attorney's fees under the DTSA? So there are notice requirements under the DTSA, and I'm not going to recite the actual notice requirement. We've worked with clients, and I know I was talking to Rich offline about this, to come up with an actual notice requirement that can be placed into employment agreements or confidentiality agreements. And we're happy to discuss that with you. But one of the big takeaways I want, everyone on this presentation to think about is, if these notice requirements are not in the confidentiality agreements or the employment agreements, at least under the DTSA, you may not be able to seek the attorney's fees under the provision that I referenced earlier. And that's an important thing. Now, there's another important point, which is, let's talk about for a second whistleblower protections. So I'm sure many of you are familiar with whistleblower protections at the state law level. And we've seen a variety of new whistleblower protections under state law, and that's for another day. And perhaps, Shai, we can come back and talk about those. But under the DTSA, it does have an immunity provision to whistleblowers who ultimately disclose trade secrets and this confidentiality to the government, or in the course of reporting the misconduct by way of a lawsuit that's brought under seal. So employers are required to provide notice of that whistleblower protection in their agreements with these employees. And I'm sure that you've picked up on now that I've talked about a lot about notices, right? Notice provision relating to attorney's fees, notice provision relating to the whistleblower protections. So although the DTSA may sound like a great statute that can get our way into federal court, we need to make sure that all of the right protections for the company and notices are provided in the actual agreements themselves, which is important. And we've been working with many clients to address those issues. Now, one of the other things that, and we can talk about this later, Rich, but I do want to allude to it because you did mention it, right? This idea of going into federal court versus state court. And one of the things, federal courts are becoming more familiar with these types of cases now that the DTSA exists. So as I mentioned, right, within the past 2 years, we've seen 75% of these trade secret misappropriation cases being filed in federal courts throughout the country. And with that comes more experience for these federal judges who already have considerable experience in this area, and they have better experience with respect to discovery, ESI, and all of the issues that come along with the discovery that tends to be necessary in these types of cases. So that's another benefit of the DTSA and why companies have been bringing these claims in federal court. And another thing to note about the DTSA is it doesn't prevent companies from also bringing their state law claims in federal court. So we've seen many cases where the company will bring both a DTSA claim and a state Trade Secret Act claim in federal court, along with many others. So those are a couple of, I think I wanted to touch upon. And Rich, if you have anything else to add, of course, feel free to do so. But I think that those notice requirements are very important and can have drastic consequences if they're not considered properly.
Those are good points, Chris. I wanted to also mention that attorney's fees, the imposition of attorney's fees against a departing employee can often be the leverage you need to get the departing employee to agree, either voluntarily in a settlement agreement or in a TRO and permanent injunction on consent to stop using your trade secrets, because it can be very costly if there's going to be the imposition of attorney's fees against the employee. But you don't need to rely on the DTSA or a State Trade Secrets Act for attorney's fees. You can also put that into the loyalty agreement for a violation of any of the provisions of the loyalty agreement. But here's a real decision point that we work very closely on with clients. Should the attorney's fees provision only favor the company, or is it fair that it should, the prevailing party, employee or employer, should have his or her attorney's fees paid, even if that means that the employer may be subject to having to pay the employee's legal fees? It's a hard question, because Yes, you can draft it in a way that just favors the employer. Are you going to get pushback from your workers? Now, maybe what you can do is limit it, attorney's fees, to the two types of disputes an employer is most likely to prevail on under a loyalty agreement: non-solicitation of customers and return of company property. Again, it's just a thoughtful analysis rather than jumping to the conclusion that you should or should not have a particular attorney's fees provision in your agreement. Does your company require departing employees to notify you about the name of the employee's new company and their new duties? Okay, we're over 50% participation in that question, and it looks like overwhelmingly close to 90% do not have this provision. We would strongly recommend it. It's nothing more than what you can just draft in a loyalty agreement. These types of provisions are necessary in many ways for you to be informed fully about whether you are able to enforce properly the provisions dealing with confidentiality and also non-solicitation of customers or non-competes. With this type of clause, you're in much better shape than you would be if you didn't have this clause, because otherwise you have to do some investigative work. Well, where did the person go to? What is their job, at this new place going to be? With this type of provision, the employees are required to notify you. If they don't, they're in breach of the contract, and it makes it much easier to go into court. One of the types of clauses that I like in loyalty agreements is a dual notification clause. The employee must notify all prospective employers that the employee has signed a loyalty agreement with a confidential information and non-solicitation of customers clause, and a non-compete if applicable. The employee must notify the company as well when they have accepted an offer, naming the new company, describing the duties, and providing the earliest starting date, and informing the company if the starting date changes. If the employee fails to do either, as I mentioned, the chance of success in a lawsuit increases considerably because of the employee's breach of his or her contract. And as mentioned, it's also very useful information, for companies to have, so they can really meaningfully protect their legitimate business interests. Michaela, if you can flip to the next slide, that deals with training. So in terms of the training, it's not a long-term training, not a long training. It's a 10 to 15 minute training about preserving confidentiality of trade secrets information, need to return and not retain company property, what is and what is not company property, need to honor restrictive covenants in the loyalty agreement, the costs of legal fees to the employee if he or she does not honor their contractual commitments, and the damages the employee may incur if the loyalty agreement is violated. And the reason why I like to have a 10 to 15 minute training for clients is because some people, new employees, they just sign every agreement. They don't even read them through. It's really important that employees understand these agreements, what their obligations are, what they cannot do, what their risks are, and what the damages may be if they violate the loyalty agreement. The more such information is known to employees, the far fewer employees are likely to violate your rights. Management and rank and file training can also occur on a yearly or biannual basis for, again, 10 to 15 minutes as part of an annual or biannual compliance type training, just to remind people how important it is and that they have signed these types of clauses.
What I wanted to add is what we've seen in some of the litigations and what the courts tend to look at is, what did the company do to protect its trade secrets? What type of things did they do? Where are those trade secrets located? Who has access to those trade secrets? So I think what Rich was saying is critically important, because when you're able to show the court, well, we have rank and file training on this specific thing. We take our trade secrets very seriously. We not only train individuals, but we silo that information, and only certain individuals have access to it. So I think thinking that from a litigation standpoint as well, that is a tool in our toolbox that we're able to show the court as to how the company treated those trade secrets. But back to you, Rich.
Let's talk about getting what you need to go into court to have what we refer to as a bang-up case that you should expect to win. First step, setting breach traps with certifications at exit interviews. The loyalty agreement ideally should require an employee to participate in an exit interview and certify that the employee has and will comply with the employee's obligations in the loyalty agreement, including obligations relating to confidential information and trade secrets. The employee certification in writing can also provide that the employee certifies that he or she intends to comply with such obligations post-employment. If the employee has certified that they are in compliance, but lies in the certification form because they haven't, the likelihood of a successful court action is substantially heightened. Further, even if there is no contractual obligation for an exit interview and certification, you can still impose these on a departing employee in most instances. And we highly recommend this type of procedure to put yourself in a much better situation. So if you go to the next slide, Michaela, it's getting the dirt and goods quickly. You got to look for it. You can't wait for it to find you. You have to find out about whether property has been returned, what the employee did and did not return. If you have one of these, return of the electronically stored information, you can now find out what the employee actually has off, site in their own possession, reaching out to customers. So the points we've been discussing so far are part of a multi-step process that I refer to as a corporate protection program. And it's, a really thought through program, multi-step, where you're putting yourself in the best position to protect trade secrets, protect your relationships with valuable relationships with customers, valuable, key employee relationships, etc. So if you go to the next slide, Michaela, let's talk about the final step you may end up taking before thinking about going into court. And that is, what should you do in-house or only with an outside forensics team if you want to go into court with a bang-up case? First, you can look at the employee's emails, but not using the employee's laptop or desktop. Rather, the administrator can look at those and take a look if there's any unusual looking emails. Surprisingly, you would think that those employees that are up to no good are really careful. Oftentimes they're not. Retain the employee's computer. Don't reissue it to another employee. Don't turn it on. Keep a chain of custody. Who has it and who gave it to the next person? If there's any concern at any point that you have because you have found some information that suggests to you that the employee may have been improperly misappropriating any of your trade secrets and confidential information, you can engage a forensic computer firm to make an optical image of the hard drive. Nothing more has to be done at that point. But if you make an optical image of the hard drive, you preserve that hard drive and it can then be examined. Do some research. Has a new company been formed if the person wants to go into business for themselves? Look at LinkedIn. Speak with current employees. Interview them in a non-formal way. Get some information. So, Chris, if a company finds dirt on a departing employee, what should they do next to get a full loaf of bread when they go into court?
Right. So good question. Right. What do you do next? And I think what you need to think about is what's the right relief here? What are we seeking and what's the right relief? Now, without getting into too much of the specifics, whether it be under the DTSA or certain state laws, right? You're going to go into court and you're going to ask the court for either temporary, preliminary, or permanent injunctive relief, right? Amongst a variety of other remedies, perhaps monetary damages. One of the objectives that whether it's representing a company that is subject to these claims or a company that is bringing these claims, it's reasonably assessing what do you have and how can we be narrowly focused on what's being requested. Now, I think that the general rule of thumb for me is not to overshoot when you go into court with respect to these types of cases. I think we've alluded to enough today about overbreadth and how that can get you into real trouble. And it would, I guess, probably not surprise you the number of times we have seen companies go into court requesting certain type of injunctive relief on an expedited basis by way of an order to show cause, and then the court denies it all and says, one, these are unenforceable as written, it's overbroad, stop wasting my time, you can bring a lawsuit, but you don't need any expedited relief, and also go take a look at the case or the state of the law before you bring that type of case in my courtroom, right? So then what we think about is, do we file a complaint only? Do we file a complaint with an order to show cause asking for expedited relief and temporary restraints? Or one of the other savvy things that we've started to work with clients with is if we have a good faith belief that they have either breached the non-solicit, non-compete, or perhaps taken some trade secret information, then the question is, well, can we file a complaint and then file an immediate motion for expedited discovery? Which I will tell you, many courts are more inclined to issue expedited discovery versus temporary or preliminary restraints if the entity seeking those restraints does not come in and show each of the elements under clear and convincing evidence. So I think what Rich and I tend to do when we work together is, right, although we can never guarantee that we're going to receive 100% of what we go into court requesting, we do go into court expecting to receive nearly 100% of what we're requesting. And that's because we take a very narrow approach to this and appreciate the fact of these nuances of some of these state laws and what we can and cannot obtain by way of the requested relief. So, and I will say one more thing, litigating on the defense side of these cases as well, there's nothing better than going to a client and indicating to them, look, we've been subject to an order to show cause, and yes, we have to respond pretty quickly, but let me tell you, they're requesting a significant amount of temporary relief, and they're requesting things that we know as a matter of law are unenforceable. So we're going to poke as many holes as we can in this, and these early orders to show cause, when you are going into court and asking the court to spend considerable time on this on an expedited basis, this is your first opportunity to showcase the case to the court, right? To give them a flavor of what this case is about. And we love nothing more than showcasing to the court that the plaintiff's case is full of holes, and they're overreaching and they're overshooting, and that's a good way to get momentum shifted right off the bat. So we appreciate that on both sides of the V. And back to you, Rich, if there's anything else you wanted to add.
Well, it's a minute or two, a few minutes after one. So I want to make sure people, the main takeaway, what I think Chris was saying is that don't overshoot when going into court. Because if you overshoot, you won't come back with a full loaf. If you shoot for with what you have, sometimes all you need is an order expediting discovery. You can go into court with an order to show cause. You don't have to seek a TRO. You can just get expedited discovery. That gives you a leg up learning more, because you sometimes are not able to learn enough, even with a forensic examination. So, what I'd like to do, because it's 1:05 now, is refer, to the last part of it, which is getting your fees paid by the other side. Chris, if you could just highlight, your thoughts in another minute or two with regard to the fees, that would be great.
I think it's probably best we can just jump to Q&A, but what I will say, since I looked at a couple of the last slide, we kind of touched upon state court versus federal court, and perhaps that'll come up in the Q&A as well. But I think, Rich, getting your fees paid by the other side, at least in part, it really comes down to really knowing what the state laws allow, and also, never mind the codified laws, but what is in the confidentiality or the non-solicit and non-compete agreements that your employees have signed, or frankly, sometimes independent contractors have signed. So I think, knowing that, you could really get the icing on top, so to speak, if you can go in there with a confident case, knowing that there's a prevailing party provision, whether it be in the state law or in your contract itself, and go in and request the fees be paid by the other side. And I think that's another, significant opportunity for employers to take advantage of that some may not have in their current employment agreements. So anything else to add, Rich?
So this is really the coolest part about litigating. Nobody needs to get a judge to issue a TRO, a preliminary injunction, or a permanent injunction if you can get one on consent. And you can get one on consent when you build in breaches, when you go into court, not overshooting, because the other side doesn't want to have the court, go forward and grant a TRO, a preliminary injunction, or a permanent injunction if they know it's going to happen in any event. It's more costly for them. So if you can get them on consent, that's ideal. We just recently did that in, District of New Jersey. On consent, we got more than we would probably have gotten in a permanent injunction, including attorney's fees. So sometimes you can be surprised. You don't need to have to all the way go to the court if you can reach out to the other side.
Well, before I get to the questions, thank you, Chris and Rich, for putting together a wonderful presentation and sharing your valuable insights with us. I have like 5 or 6 questions, so I'm excited to get to them. First question, what are your views in allowing employee participation in open source projects, either related to or not related to the employer's activities?
Open source projects are, generally speaking, something where if employees participate in them, you just want to make sure that they're aware that they cannot use any of your trade secret information. Not a programmer, so I can't really tell you, but I am sure that if you confer with your, those in your company who are programmers, they can give you some guidance on whether to allow this, and also whether to allow it under certain limitations. I would strongly suggest, it doesn't have to be a formal document, but that you get anyone who's participating in these open source, projects to sign off on a 1-page short matter saying what they won't do.
Got it. Next question, and it has to relate to the issue of forum. And they're kind of 2 related questions. I guess the first question is, can't the employer choose a friendly forum as the governing law in the event of a remote worker located in another state?
Yes and no, but bear in mind, it's really a 2-part question. Friendly forum, but also a friendly law. You can designate a law for the contractual provisions. However, if someone is in a state like California and you designate New Jersey law, it's pretty clear that even in New Jersey, they will not enforce New Jersey law, they'll enforce California law if the person is in California. So you can try to do that, but you should not assume that you will be necessarily successful. What you should probably try to do is also play by the rules in the jurisdiction in which the person actually is working. With remote work, it's a little bit more challenging. Clearly, if you have good law in your home state where your headquarters are and where that person reports, you should try to use that. Next question is the forum selection. Chris, you want to touch on the forum selection?
Sure. Well, I think for the sake of brevity, I think we can move on in a minute, but I echo what you said, Rich. And I think it's very similar in that regard, which is, we see it all the time. You have forum selection clauses and whether it be federal or state or certain state specific forum selection clauses. And I think what I like to do at the outset when I review these in connection with either pre-litigation or advising client, looking at them and going through exactly what Rich just said. So frankly, I don't even think it's all that necessary for me to get into the specifics, but I think that is important as a consideration as to where do we want to be and why do we want to be there. But then in the background, right, do we believe that if we do bring a case in that particular forum, we can sustain that case in that particular forum, or that, right, it's going to get kicked for a variety of reasons.
And I think that the basic takeaway is it is a strategic consideration depending on how likely you will be able to succeed in a particular forum under a particular law, and then you make your decision.
Exactly.
Got it. So that's interesting. Just to, because the second question basically was, by putting a choice of law in the contract, does that protect against the peculiarities of other states' laws, even if the employee is located there? But I guess it doesn't.
It doesn't.
Wow.
It is unlikely in most instances. There's a choice of law doctrine that we're all familiar with, but we've mostly forgotten until we read up again and say, oh yeah, I remember this. But it's a conflicts analysis. And, there's questions about whether there's a strong public policy or whether the nuances between one company, one state's, laws and another is essentially, the same. So it is a really good question, and people struggle there. I think the important thing, Shai, the takeaway is, don't just assume you should use this or that state. Give it some thought.
The next question has to do with notification. I think one of the pieces of advice you gave was, and a very clever piece of advice is, if an employee is departing, that they have to notify the employer of, whether they have clients or where they're going or, what they're doing, the general notification requirement. So there's two questions. What if an employee refuses to notify and just keeps it secret? And then secondly, what if you have it in the agreement, but you never really enforce it? How do you practically, force an employee to tell you or get you to notify, or get them to notify rather?
So you're correct. You can't force someone. If they give you notice and they're out the door and you have no way of communicating with them, but if they have an obligation because in the loyalty agreement and they breached it, that puts them in a very unfavorable light. And many inferences will be potentially, regarded as favorable to the company because you're not in a position to have that information. However, even if employee has bolted, it is still capable of communicating with the employee. You send a letter. Dear employee, under this provision of the loyalty agreement, you're required to give us this. Please do so within the next 48 hours because we want to make sure that we're in a position to determine how and if anything you have complied with your obligations and how we can best protect our legal rights.
Got it. And again, general PSA, folks, if you have questions to submit, follow Michelle's lead and go ahead and submit some more questions. I still have a few more to go through, but just, since it came in timely, what do you recommend for national companies operating in multiple states?
In all honesty, maybe 5-6 years ago, you could have a general, a loyalty agreement that didn't have to have so many different things. In this state, this, and in that state, this provision is not applicable, and you substitute this. Unfortunately, states have in the past 6 to 8 years been legislating so much, and the courts have also adjusted their thinking of these clauses. So it is a good idea to have a starting point, but you do have to be aware of some of the nuances, especially statutory changes in the law, like what Chris was mentioning, in places like Massachusetts, in Illinois, and in other states, maybe even soon in New Jersey. What you definitely don't want to do is to have a provision that on its face would violate a statute. So you do have to have a savings clause in anything that you currently draft, so that if there is new legislation, you're able to, say, well, it's not applicable because it says the fullest extent, consistent with, law. In addition, that goes back, Shai, to the question, do you amend or do you replace? You can amend these things a lot easier than replacing them. Say, hey, in Massachusetts, there's this new law. Therefore, we're going to, propose an amendment that is consistent with that law. If agreeable to you, please sign. Hey, at least what you've done is you're aware of that new law and you've tried to make the change. It's much easier than substituting a brand new loyalty agreement.
And Rich, one more point I wanted to make, just a real life example. It wasn't more than 2 weeks ago. I was appearing in front of a judge, and the judge had commented on the other side's non-solicitation agreements that they're attempting to enforce, noting that it appeared this federal company that will go unnamed had used copy and paste of the non-solicitation provisions and the state-specific choice of law provisions, and that clearly the company was not thinking about this on a state-by-state basis. So that's a real life example of a court picking up on that specific issue and noting it, and noting his doubts as to whether the state in question followed the same laws of the state that the company seemed to use as its general choice of law provision.
And Shai, this is why, one of the reasons, more so than ever before, that I'm not in love with non-compete clauses, because that area of the law is so much influx. If you don't need it, don't include it. With regard to non-solicitation, return of company property, confidential information, that law is not really changing. That's consistent. It's the area of non-competes, which are regarded in some ways as restraints of trade or unfair, because many of these large companies even have their, the people who flip burgers sign these things, that has reached the attention of state and even federal, regulators with the antitrust, aspect. So if you don't need a non-compete, don't put it in except for those folks that you feel it's absolutely essential to protect your business interests, that you have those non-competes.
Got it. I did warn you guys that it would be an experienced audience with their questions, and we're not letting up. So the next question, can you discuss the interplay of privacy, BYOD, right, bring your own device, and standard requirements for departing employees to give access to personal accounts and devices without prior indicia of trade secret misappropriation?
Well, I'd offer that to Chris, but he's going to push it back to me. Let me just say,
you just handled this, Rich, so why don't you talk about it?
So these are extremely difficult issues. However, let's be very clear. What belongs to the company is not usually at issue unless you fail to take protective action, as Chris mentioned. If you require things to be password protected and you have agreements and or employee handbooks that limit what people can do, you should be okay. Obviously, if you're aware that someone has company information and they sent it to their Gmail account, that's okay, as long as you're, if you allow it. Some companies forbid it absolutely, and they're required to forbid it. But if you allow it, your handbook or the agreement has to also state, to the extent that you have any such, property outside the company's, devices, you agree that you will maintain that, confidentiality and not compromise it, use it, disclose it, or give anyone else any access to that information.
All right, so we have 3 more questions, and I guess this is my last call for questions. What provisions tend to have the most effective deterrence impact on preventing contractual violations in the first place?
Well, Shai, that is the perfect reason why we have something that is sometimes a 6-point, sometimes 8, sometimes 12-point corporate protection program, because no one thing is going to do it alone. The legal fees may not scare somebody, but the certification may. Something in the nature of you must notify, your new employer of these particular items. You must tell us, what, company you've gone to and what your duties are there. They all, together with training, will help you to limit considerably the number of instances where you have to even think about going to court. It's absolutely stunning. I have spoken to people who are so, observant of their obligations, who are going to another company. And the new company asked me as their lawyer to talk with them. And they've done everything right, they think. And then I realized, oh, you didn't turn this back. Why didn't you give that back? Well, I created it. It's my work product. Well, it may be your work product, but it doesn't belong to you. You have to turn it back. So the education part, the 10 to 15 minute training at the outset of employment and during, 1 or 2 year, compliance training is very helpful to let people know, even those who are trying to be observant, what they need to, recognize belongs to the company and what's not theirs.
And one thing, Rich and Shai, that I just wanted to pick up on Rich mentioned is a similar topic in the sense that what we tend to also see is when we are representing a company that has been brought into a case as a defendant because they happen to have employed an individual who allegedly breached their non-compete or non-solicitation or confidentiality. I think one of the things that we often look to is, well, at our client, right? Did they have this employee sign something that, I've referred to as a rules of the road, confirming that the individual is compliant with all of their existing obligations, that they have returned all the, personal devices of its former employer, right? That at least, it's never going to be perfect. It's never going to completely shield the employer. But at the end of the day, what it does is it shows that you're taking steps, right, to not only to ensure that your employees who are, recent hires are maintaining their obligations to former employers. And I think that's an important point as well.
Got it. So next question, can you repeat the statement about non-solicits and the return of company property being two areas that I'm pretty sure you said the employer is most likely to prevail on?
Yes, absolutely. I love that part because that's where if you shoot for those two things. So one of the things that you are pretty sure about is if you have a non-solicitation clause, which isn't just non-solicitation, but not doing business, and someone who is departed is doing business with that company, you're going to likely, you should go in there expecting that you're going to get relief from a court. So there's no question about that. No one can make an argument that, oh, this isn't trade secret or not. The next part is returning company property. Returning company property does not mean that you return confidential information, does not mean that you return trade secret information. You have to return company property. That means if you have any document at all in your possession and you don't return that, you can expect the company is going to win that. It's if you claim that it is a trade secret misappropriation, well, it might not be a trade secret and the person may not have misappropriated it, but what they haven't done is they haven't returned it. So those are the two areas that are the easiest ones to make sure that you focus on, and sometimes are the only two you even go to court on, seeking temporary relief, because those can be so guaranteed of success. But at the same time, you might want to only leave the attorney's fees to those provisions, because you have very little chance that if you seek to enforce those, you're not going to win. What we worry about is if you try to enforce the non-compete, Shai, or the trade secrets, you might lose, and then you have to pay their legal fees. That is not career enhancing for most in-house counsel.
Definitely not.
No, it's not.
Can an in-house counsel sign a non-compete?
Chris, I'll let you start off on this.
Yeah, I would say general answer to that would be no. There's certain states that have very, very specific requirements that need to be satisfied in order for certain professionals to be subject to a non-compete. But generally speaking, my response to that would be no.
And in New York, there's a Court of Appeals case with regard to that because it recognizes the client's right to have a lawyer of his or her choice. And therefore, a company cannot interfere with a client right to that. It always surprises me when that is not recognized in some states. It may not be recognized, but generally speaking, it's not it's not something that I think we would typically want to put in with counsel. However, if it is in counsel, inside counsel's provisions, and there is a provision that carves out anything that would not be fully consistent with law, I think a company doesn't need to worry as much. You only have to research that issue as a company, before you want to enforce it, because the law may not permit you to.
Got it. So quick follow-up question. Does this mean the non-compete against in-house lawyers is unenforceable, or should the in-house lawyer just not sign an agreement with a non-compete?
Unless there's a specific statute or a court decision like in New York that says they're not enforceable, I would never, as an in-house counsel, raise any issue about it. However, if you sign as an in-house counsel and it's unenforceable, it's not going to make it enforceable, even if you should know better because you're a lawyer. So importantly, it's not worth making waves about something that you're on the right side of the law with to begin with. However, if you're responsible for drafting these things for other lawyers, it's probably worth looking at the state of the law in especially in the corporate headquarters, the state where the company is headquartered, and making sure that it's not inconsistent with that law.
And Rich, one other thing I wanted to note, one, as we've seen in many states, right? We know it's prohibited outright. But I think another one that we've gotten this question before about in-house counsel or legal counsel is what are they performing with respect to the practice of law at the company? So, sometimes I've seen it where you have an in-house counsel, but they're not necessarily practicing law all the time. They may be doing that 40 or 30% of their time. So, I think the question is a very good one, because perhaps in that scenario, the company could attempt to enforce a non-compete if it doesn't relate to the practice of law. But as I noted earlier, I think generally speaking, if we're talking about most of the states, it's going to be prohibited.
And I think we saw an excellent chat, Shai, that someone says it's also in Ohio and probably other states, it's unethical conduct to, draft those types of agreements, or for a company to use those types of agreements. If you're a lawyer, having another lawyer sign those things. Now, Chris's point is that there's a lot of in-house counsel who are, have additional responsibilities. For example, chief compliance officer. And so to the extent that the person is wearing both hats, I think it's ideal, if you're going to have those things, to make sure that it is for non-legal roles that they have.
Got it. Okay. That makes a lot of sense and is pretty crystal clear. Thank you. With that, we'll conclude our Q&A. It was a very active bench. You guys did a great job. So thank you very much